presentation. Our presenter is available. He has court, so Evan Kulik's here from my office, but he has to leave at about 10 to 2. So we have him for just 50 minutes.
Okay, yeah, I think if we move through the roll call of attendance and ROA, then I think we can move into that. All right, just one moment.
Thank you.
Okay, and I see our recording has started. Thank you, team, for that. All right, moving into attendance. Matt Malone.
Here.
Melissa Klawoon.
Here.
Chief Eamon Kraus. I think I saw Melvin.
Yes, here.
Okay, thank you. Ellen McDonald.
Here.
DA Becton.
Present.
Louis Torona. Lynn Mackey.
Here.
Ashante Smith. Gilbert Salinas. Tamisha Walker. Jeff Landau.
Hi, everyone.
Michael Pearson. Shayla Bonner.
Here.
Stephanie Medley.
Here.
Thank you. Renelle Ellis.
Present.
Cheryl Sutton. Gigi Crowder.
Here.
And Carlos Fernandez. Okay. Now, Ellen, would you like me to share the agenda?
That would be great. When Evan presents, he would like to have share screen to do his PowerPoint.
Okay, great. And then next we can move into the ROA, approving the record of action from our last meeting.
Great. And did you want us to take public comment now?
Yeah, I think that sounds fine. Yeah.
Great. So at this time, we will take public comment for any item under the jurisdiction of the Racial Justice Oversight Body, but not on the agenda. Anything not on the agenda today that folks have public comment. All right, scrolling for hands, but not seeing any. Give it another few seconds. Any items for public comment that are not on today's agenda? All right, let's move along to approving the record of action. Our last meeting was the August 4th, 2022 quarterly meeting. If you look at pages 3 through 5 of our agenda, what occurred at that meeting is detailed there. Does anyone have any corrections or comments about the record of action? And first, I'll take any comments from the our job members. And thank you, Patrice has just put the link to the agenda in the chat there. Anything from Racial Justice Oversight Body members about the approval of the record of action? No? And anything from the general public, comments about the record of action from our August 4th, 2022 quarterly meeting? All right, anyone have a motion regarding the record of action?
I'll make a motion to approve.
Motion from Jeff.
A second.
Second from Shayla. And Christina, can we take a vote?
Absolutely.
Thank you.
Melissa?
Yes.
Melvin?
Yes.
Ellen?
Yes.
DA Becton? DA Becton, I'm sorry, I didn't hear your response.
Yes.
Oh, yes, thank you. He's not here. Lynn Mackey?
I'll abstain. I was not there.
Jeff Landau?
Yes.
Shayla?
Yes.
Thank you. Stephanie?
Yes.
Renelle?
Yes.
And Gigi?
Yes.
Did I miss anybody? Any voting members? Okay. Motion passes.
Thank you, Christina. So we're going to move on to a presentation. And this is going to be from Evan Kulik, who is a deputy public defender in my office at the public defender's office. He's actually in our alternate defender office, which handles conflict cases. Evan has been in Contra Costa practicing as a deputy public defender since 2010 and practiced before that in another county. And his work under the Racial Justice Act has been really groundbreaking and has had a statewide impact, garnering Evan the 2022 California Public Defenders Association Defender of the Year Award that he was just honored with in San Diego last month, or back in September. And one of the reasons Evan's litigation has garnered so much attention is that he's really doing this litigation at a very high level, calling renowned experts, and litigating under the Racial Justice Act, something we'll talk about a little bit later, is something that requires an incredibly deep capacity from public defenders and public defenders' offices. So I think it'll be exciting for this group to hear a little more about what that litigation involves. Evan was also known for his work in the People v. Silas case. And in that case, Evan skillfully preserved the record. That was a case where the district attorney, the deputy district attorney, kicked off every single African-American juror on the panel. And she used the reason that one of those jurors supported Black Lives Matter. And there was a very lengthy appellate decision in that People v. Silas case that talked about striking individuals that supported Black Lives Matter, and that was not a race neutral reason for striking the jurors. So it was Evan's really extensive work and his deep work in the trial court on that case, and then the case that he's going to talk a little bit more about today, the People v. Bryant case, that really I think have had impact statewide and impacted Black and brown people going through our systems across the state. And one of the things you'll see, and one of the reasons we thought this would be a good presentation for this group, is there's a lot of intersection. What public defenders are being called on to do right now is to really do deep data analysis, to almost be, statisticians around, for example, the minute issue. If we had recently, a case out in our Pittsburgh court earlier this week, and we looked, and on that type of charge, what were the demographics of folks being charged? Are we able to really delve into that and see that the cases being brought to us are being charged in a way that's race neutral? Are folks being arrested or brought in from some communities and not others? And so the Racial Justice Act really gets to the heart of looking at our system in a different way, and to try to ensure that individuals are treated fairly across the board. So without any more ado, I'll turn it over to Evan, who again is busy litigating. So we'll only have him till about 1:50 so that he can get back over to court here in Martinez and finish his hearing.
Thank you, Ellen, for that wonderful intro, and thank you all for inviting me to join you today. I will attempt to share my screen to get this PowerPoint going. So give me just a second. All right, I can never tell, is the full screen version showing or the previous screen?
We're seeing the preview screen.
Okay. Great. So my goal today is just to spend a little bit of time going over big picture. What is the Racial Justice Act? What are the different elements of it? what are the different ways in which the act can be violated, or a person can bring a challenge under the act, and then to discuss a little bit more in depth what racially discriminatory language means under the act, and how the People versus Bryant case was litigated very recently, and to highlight a few other cases that are ongoing in Contra Costa, or some sample challenges. So when we talk about the Racial Justice Act, we're actually now at this point talking about two separate bills. So the initial bill, Assembly Bill 2542, was passed in 2020 and took effect January 1st, 2021. And that was titled the California Racial Justice Act. The additional bill that was just passed this year and will take effect in January is called the Racial Justice Act for All Bill, Assembly Bill 256. And that bill added some clarifying language into the statute and made a mechanism for retroactive application. There's going to be a staggered rollout on that retroactive application, such that in January 2023, death penalty cases and cases where there are immigration consequences will have immediate ability to raise claims, even if those cases are final on appeal. The following year, 2024, there will be an ability for people whose cases are final on appeal but are still serving a prison sentence to raise claims, and there's some additional rollout beyond that. But when I refer to the Racial Justice Act, I'm now kind of talking about these two bills together, which are codified in California Penal Code Section 745. So the basic concept here, 745 subdivision A, says the state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. And under subdivision A, there are 4 ways in which the law can be violated. And these are the 4 subsections under A. 1 is exhibition of bias outside of court or trial. 2 is the use of racially discriminatory language or exhibition of bias in court during trial. 3 is evidence that a defendant is overcharged by race and that there's a statistical disparity in the county of charging. And 4 is that the defendant is over-sentenced by race and there's a statistical disparity in the county. Penal Code 745 sets up 2 stages for a Racial Justice Act challenge. The first stage is the prima facie stage, and that is the initial motion that's brought by a defendant or somebody who's been convicted, alleging that there was a violation in their case. The prima facie stage, the court looks at the allegations and assumes the alleged facts to be true. And the court has to consider, if these alleged facts are proven, is there a substantial likelihood that the Racial Justice Act has been violated? So this is not where there's contested debate over the proof of the facts, but the judge is just looking at this prima facie standard. If these facts are true, does that establish a violation of the Racial Justice Act? The evidentiary hearing phase is then, if the court finds a prima facie stage, there's a mandatory evidentiary hearing. And at that hearing, the moving party has to bring evidence to prove by a preponderance of the evidence, which we know is 50.1% or more likely than not, that the Racial Justice Act was violated. So we got this 2-step process. I want to give you just basically the big picture highlights of the Racial Justice Act. It applies to in-court and out-of-court statements or bias. It's violated by explicit or implicit bias. No one must be found to be racist or have acted in a racist manner. That term racist is nowhere in the statute, because there's an understanding that implicit bias doesn't require proof of intentional bias. Another way to say that, intentional discrimination is not required to establish violation of the act. For current cases, there is no requirement to show that bias impacted the outcome or the verdict in the case. In legal terminology, we call that prejudice. It's a little confusing because we're talking about bias here, but the term prejudice in this legal context talks about impact on the outcome. And there are some instances where somebody has to prove, hey, this thing that happened impacted the outcome. So to be clear, cases that are currently ongoing, there's no requirement to show any impact on the outcome. For closed cases, this now brings in the Racial Justice Act for All's retroactivity application. There still is no requirement to show prejudice on the outcome for statistical disparity claims. Those are the claims brought under subsections 3 and 4. But there is, for this retroactive application for exhibition of bias or discriminatory language claims, when a defendant establishes exhibition of bias or discriminatory language, either out of court or in trial, that claim that the Racial Justice Act was violated in this case that is closed and final can be overcome if the district attorney proves beyond a reasonable doubt that the violation did not contribute to the outcome. So it basically is a burden shifting mechanism. The burden is initially on the defendant to show that there is a Racial Justice Act violation, and then the district attorney has the opportunity to prove beyond a reasonable doubt that the violation did not impact or affect or contribute to the outcome or the verdict. I want to do a little bit of a deeper dive into Penal Code Section 745A2 and this concept of racially discriminatory language at trial. Again, this includes both explicit and implicit bias, regardless of the intent of the speaker. It includes racially charged or racially coded language. We're not just talking about racial epithets. It includes language that invokes stereotypes. And when there's evidence that particular words or phrases are used disproportionately or exclusively in cases where the defendant is a specific race, is evidence that can be used to show that it's racially discriminatory language. So I want to give an example. Just a few weeks ago, there was a misdemeanor domestic violence trial happening in this county. And a Black defendant, Black alleged victim, and the defendants had a child with a woman who was also Black. And the prosecutor in this case used the term baby mama in cross-examination of the Black defendant and repeatedly in closing arguments. When the defendant was being cross-examined and the term baby mama was used, he actually corrected the prosecutor and said, "You mean the mother of my child?" Despite this, the term was continued to be used by the prosecutor. So this is an illustration of racially coded language. It's not a direct derogatory term. It's not a racial epithet, but it is language that invokes negative stereotypes commonly associated with Black men. That doesn't matter whether the prosecutor here was aware or not about what she was doing, how the language might impact the people in the courtroom. This is racially coded language. So the judge, the public defender brought a Racial Justice Act challenge after the close of closing arguments while the jury was deliberating. The judge held that the use of this term by people outside the Black community to discuss Black parents is often derogatory and used to imply bias and disrespect. The court found the Racial Justice Act was violated and gave a remedy of admonishing the jury to set aside any implicit biases or stereotypes that may be triggered by the prosecutor's use of the phrase. So when a Racial Justice Act violation is established, the judge has wide latitude to impose a remedy or a cure for the violation. And that could include granting a mistrial, getting a whole new jury. It could include something like this, an admonishment. It could include reduction of certain charges. There's a carve-all in the statute that says the judge may impose any remedy that is lawfully authorized. So turning to the case that I spent the better part of the last year and a half litigating the Racial Justice Act challenge, People versus Gary Bryant and Diallo Jackson. This was a case that went to jury trial back in 2017. I was one of the attorneys at that trial, so I've been representing Mr. Bryant for about 8 years in total. And our litigation just recently resulted in the judge finding that there had been a Racial Justice Act violation at trial, and judge issued a 71-page order discussing in depth all the reasoning, and ultimately ruled that the conviction and sentence were vacated and a new trial has been granted. We got some major national press covering this case because it was the first case of its kind. It is the first ruling in the state of California setting aside a conviction based on a Racial Justice Act violation that occurred in trial. Should mention also California's law, the Racial Justice Act, is the first of its kind in the nation, is the most sweeping legislation in covering racial bias in the criminal system, and it is the only legislation or law that acknowledges the ills of implicit bias and allows for proof of implicit bias to satisfy the violation of the law. In our federal rules, the federal standard from the US Supreme Court that's been longstanding precedent is that to show prejudice or bias in a case, that the defendant would have to show proof of intentional discrimination in order to achieve that, and the California law does not require that. So this is basically the first of its kind in our state, in our nation, and we'll go into it a little bit. So as Ellen mentioned, this work cannot be done by an attorney alone, but requires expert witnesses to present to the court and explain how the Racial Justice Act is violated by particular language or activities. So in our case, we had 3 expert witnesses: Professor Bowman from Arizona State University School of Law, who wrote a law review article confronting racist prosecutorial rhetoric at trial. And then we had 2 experts to discuss the use of rap music in the trial. The first was Professor Andrea Dennis from University of Georgia School of Law. She wrote the book Rap on Trial, and had an article from 2007 on rap music lyrics being used in criminal courts. And then Charis Kubrin from UC Irvine School of Criminology was the final expert witness, and she'd published several peer-reviewed experimental research articles in journals in the criminology field, looking at societal views of rap music, negative impressions, and how that's intertwined with race. So in our case, we brought 2 main Racial Justice Act claims. The first was that the prosecutor's use of slang terminology in closing argument was racially coded rhetoric. The second being that the use of rap lyrics and interpretation by police as literally true confessions invoked negative stereotypes. So first, with respect to the slang terminology, the court ruled that it was sort of a mixed bag. She went through and examined each of the terms, how they were used, how many times they were used, what they were used in reference to. But the court ultimately ruled that some of the slang terminology used by the prosecutor in this instance constituted racially coded language in violation of the Racial Justice Act. This included the use of the terms pistol whip and drug rip. Each of these slang terms was used by the prosecutor in the first instance, meaning it wasn't repeating a witness's testimony or something that was otherwise part of the case, but was rephrasing witness testimony and using these terms. The terms the court found were more graphic and more violent than the actual description by the witnesses, and that they emphasized stereotypical association of Black men and violence. Each of these terms was repeated multiple times, and the court found that the repeated use primed the jury and activated implicit bias. One of the components that we presented in this hearing through the presentation of the expert witness, Professor Bowman, was basic concepts of implicit bias and defining for the court terms like stereotyping and othering and priming. And priming is the activation of stereotypical negative associations between a race and certain traits. So thinking about racially discriminatory language at trial, this is just one example where the use of slang terminology, because it was being used to discuss violent acts by the defendants, who were African-American men, because it was not repeating witness testimony, but being used in the first instance. And because of the repetition, in this case, that was racially coded or racially discriminatory language. Some other examples that I wanted to just put out there to be thinking about include slang that's racially coded in context, the use of a street name instead of a legal name. This is sort of under the same idea that in a court of law, we're speaking in formalities, and it dehumanizes someone to refer to them by a nickname as opposed to their formal legal name. Use of animal metaphors, use of the N-word, even when quoting others, and that's something that the judge found in our case went into the discriminatory language analysis. Unnecessary focus on physical characteristics, such as skin tone or dreadlocks, if those don't matter, right? If it's a case where a witness is identifying somebody and what physical characteristics they recognize to use to make that identification is something different than sort of unnecessary focus on characteristics that are racially focused. Arguments based on stereotypes, use of terminology like super predator that has been shown to have been used to discuss particular communities. Negative discussions of particular Black or Latino neighborhoods, mocking or imitating a client's voice or physicality in a way that brings up racial stereotypes. These are all things that could come up in trial that would fall under this idea of racially discriminatory language and be a violation of the Racial Justice Act. So on to the second issue, the use of rap lyrics. What we established through the hearing was that there's a historical and fundamental connection of rap music with the Black community, that there are negative stereotypes of Black men that perpetuate negative societal views of rap music. Rap is a complex art form with literary conventions, such that literal interpretation of rap lyrics relies on negative stereotypes of Black men as intellectually and artistically inferior and violent. So these literary conventions involve metaphor and bragging and something called the collective conscious. So ideas that people may be using first person to describe things that happened to their neighbors or in their community, not actually to them, but it's part of the community narrative. Some of the ideas about metaphor, such as a firearm, is often used as a metaphor for a microphone, and the idea of violence for rap battles, and that proving one's prowess as a rap MC is often established through violent metaphor and not literal violence. And we know through the research of Professor Dennis that no other genre of music is used in courts in this same way. Academic research supporting these arguments was presented through Professor Kubrin, who published peer-reviewed studies in journals establishing a strong negative societal associations with rap music and rap artists that are connected to race. She found strong evidence of implicit bias with her studies, finding that when she provided violent lyrics in a study, she told some study participants that these were rap lyrics, some that they were country, some that they were heavy metal, and found out what their perceptions were. And there were strong negative perceptions around the rap lyrics and assumptions around the rap lyricist, that they were violent, that they were a gang member, and 80% of respondents assumed the rap lyricist was Black. So some participants were given race data and some were not. And when they were not given race data, overwhelmingly participants assumed the author of the violent lyrics, when they were told those lyrics were rap, was African-American, and that correlated with very strong negative views of the artist. So the court ruled here that more likely than not, the use of rap lyrics in videos at trial triggered the jury's implicit racial bias against African-American men in violation of the Racial Justice Act. So the timing of this decision was very close in time to the legislature passing AB 2799 just a few weeks ago. Here's a tweet from the governor where he had a Zoom with a bunch of very famous rap artists and industry folks signing the bill. And so this legislation goes into effect in January, and it requires the court to conduct a hearing outside of the presence of the jury before evidence is presented in a trial when the prosecution seeks to present creative expression, including rap lyrics. The court has to have this special hearing and take into account whether there is specific relevance to the lyrics as opposed to generalized violence, whether there's risk of negative character evidence coming in against the defendants, and whether there is a risk of bias or prejudice being introduced into the trial based on the use of the rap lyrics and the academic research that's been presented on that. So our case, the Bryant litigation, had been ongoing for quite some time, and this bill, well, not precisely in response to the Bryant litigation, definitely took our case into account because, of course, there hadn't been this mechanism to have a gatekeeper function for the judge to determine whether the lyrics were relevant. And in Mr. Bryant's case, the lyrics that were presented were generalized themes of violence and guns and terms like gang and mob, but the lyrics did not specifically discuss the shooting at issue in the case. So the research has drawn a strong distinction between rap lyrics that are specifically describing a particular act of violence having much more probative value than generalized themes of violence, which should not necessarily be taken literally, given the artistic metaphors and other natures of rap music. So we now have this legislation in California, hopefully will prevent something happening again, like what happened in Mr. Bryant's trial. California is leading the way. New York has a similar bill that's been introduced into legislature, and there's a federal bill that has been introduced into the US House that would create a similar gatekeeper mechanism to prevent inappropriate use of rap lyrics in court. So I just want to briefly touch on the subdivisions 3 and 4 statistical disparity violations. This is a data-heavy analysis because it requires proof that both the current client, the defendant, is overcharged or over-sentenced, and that there is a statistical disparity within the county. So it requires getting records. The Public Records Act applies in these cases, and charging data, arrest data, sentencing, conviction data, that can all be obtained through Public Records Act request to the DA's office, the California Department of Justice, the California Department of Corrections for sentencing data, and to police agencies for arrest data. Now, police agency arrest data is just beginning to be required to be collected. RIPA, the Racial Profiling Act, has been in effect for a little while, but there's been a slow, staggered rollout of when agencies are required to report arrest data, including racial information, based on the size of the agency. So Contra Costa agencies are just beginning their reporting requirements. The other mechanism for obtaining information to be used in these kinds of challenges is 745 subsection D. So within the Racial Justice Act, subdivision D contains the mechanism for a motion for relevant data that can be brought in the trial court. The moving party has to establish good cause to get the materials. So this is before bringing an actual Racial Justice Act violation claim, is an ability to bring a motion to get data towards that. So obviously the court can't require you to prove that the violation's been established in order to get the data to attempt to prove the violation. And so the standard's been set by the Court of Appeal in a recent case called Young, that the good cause in order to get that order from the judge for the government to provide relevant data is a plausible justification that a violation of Racial Justice Act could or might have occurred. So once you have this data, the question is comparing the defendant in a particular case to similarly situated individuals accused of committing the same conduct. And so the areas where this is possibly going to come into play relates to discretionary charging decisions, right? So when you have crimes that can be charged as a felony or a misdemeanor, drug sales versus drug possession, attempted murder versus assault, in murder cases, death versus life without parole versus life with parole. These are just some examples of discretionary charging decisions, areas where you may see people who are alleged to have committed the same or similar conduct, and thus are similarly situated. And the question is whether there is a disparity based on race, or whether the defendant at issue is charged more seriously than similarly situated individuals of other races. So a quick case study, gang-related murder. Murder with a gang enhancement can carry life with the possibility of parole. Murder with a gang special circumstance can carry death penalty or life without parole. So this is the similarly situated conduct is murder with gang allegations, two ways of being charged. One carries possibility of parole and one carries no possibility of parole. And the data that we've been looking at is depicted in this chart here, where we've laid out blue representing the Black percentage and orange representing the non-Black percentage, or all other races, looking at the percentage of the Contra Costa population versus overall for all forms of gang-related murder, that more than half of people charged with gang-related murder in Contra Costa for the last 7 years are African-American, and then breaking it down to defendants charged with murder with gang allegations who are charged with the gang allegation that carries possibility of parole. Slightly more than 50% of non-Black defendants are charged with the gang enhancement that allows for possibility of parole. But when you look at the percentage breakdown of defendants charged with murder with gang enhancements and as a special circumstance carrying life without possibility of parole, then that gets to close to 60% African American. So this is just one example of obtaining data, pulling it out, and looking at the second component. You've got to ask, well, is this defendant charged more seriously than similar situated people who've committed the same conduct? And then what is the pattern? And so this is just a case study or an example of looking at how to obtain data to identify that pattern, which was getting public records data for the last 7 years of all homicide charges with gang enhancements, and then breaking it down. Here's a charging disparity. There's more serious version of charging, life without parole, less serious version, life with possibility of parole, and looking at some of the patterns there. So we've gone through the basic structure of the Racial Justice Act and wanted to give you some examples of real world application in our cases here in Contra Costa County. So thank you for your time.
Thank you so much, Evan. And I know we have just a few minutes before you need to go, but I'd love to open it up for questions while you're still here. Questions for Evan?
I actually have my hand up. Thank you,
Oh,
Evan.
thanks, Gigi. Didn't see you.
Thank you, Evan. That was very informative and a move toward the right direction. But does any of these efforts, because we have so many African Americans and people of color in our system because of efforts at law enforcement level, do any of these laws reach down to not having them actually be arrested at the same level as non-African Americans or Latinx?
So that's a great question. The Racial Justice Act can only be raised in the context of a criminal case, right? So the mechanism to bring a challenge is in the context of seeking a remedy for bias impacting a particular case. Now, the way that bias can be established might be based on charging, but it could also be based on policing. And so an example that I don't have going on right now and didn't get into today could look at arrest data. And that's why the RIPA data is really important, but like I mentioned, is just beginning to be collected. So it's going to take a couple of years for Contra Costa agencies, police agencies, to have that data that can be looked at to see how on the ground policing is before cases are even referred to prosecution.
And could you look at the number of individuals that are released on OR versus those that are not? Because that should be in our system and their ethnicity as well. I spent Tuesday at court and I saw obvious disparities with even the judge and her decision making around who could go home, who was considered safe. People with ghost guns were allowed to leave, but I'm still very emotional about that case. And I just think there's so much more we could look and peel back the layers on so many corners to improve outcomes. Thank you.
Absolutely. I think that OR decisions would fall under the auspices of racial justice. It's not something that we have the data on right now, but a challenge could be made, and it has to be, the right case where somebody who wasn't released would be the person through their attorney to bring that challenge, seeking the remedy of release based on racial bias in that OR decision.
Even how the bail is set. Thank you. Rich people go free, no matter, you could see them holding a gun and killing someone. And if they have the money, they can go free. So any reforms we can do around that would also benefit the work we do as our job. Thank you.
Thanks, Gigi. I saw one more hand before Jeff, but it went down.
Yeah, that was me. You actually started answering the question already, so I put my hand down. But really quickly, and thank you for the presentation. This is very informative. I did have a question just around some of the numbers that you presented. Do you also have numbers for the Latinx population? Or is it just broken out as Black and non-Black?
for that particular analysis that we were doing of gang murder, the disparity that we saw in the county here related to overcharging or more serious charging on Black defendants, not so on Latinx defendants for that particular analysis. But that's the work here to be done is getting the data and then thinking through, well, what is the case that I have? What's the demographics of my client in a particular case? And is there a statistical disparity, for their group?
Thank you.
Okay, and then Jeff was next.
Thanks, Evan. And I know you're needing to go in just a moment, but I was thinking in terms of what this group can do and what kind of how we can move forward with it. Just kind of speaking to for a moment the capacity to address, right? Many people might know of cases that would be appropriate and what it would take additional resources to be able to take this on, and what we might be asking the supervisors or the next kind of relevant level if we want to support this. What kind of just speaking to what it would take, the capacity to handle this sort of litigation moving forward. Which is a way of saying we need more attorneys probably likely to do all this and different levels of professionals to do the work. And perhaps we might encourage supervisors to consider that there being additional funding apportioned for some of this work, and just lifting that up as we want to support what's appropriate in cases where it's really needed.
Thank you, Jeff. I'll probably take that one. The attorneys from my office have been knocking on my door since this passed, saying, and I want to highlight how atypical in a way the work Evan did is. I mean, he worked for months and months and months and months to dig in so deeply to one incredibly serious case and did groundbreaking work. But we need to be able to really dig into cases at all levels. And right now, with a capacity and the availability of data and the availability of our office, the concerns that my folks have brought me is that we're not able to leverage that across all cases and all clients. So we're definitely always looking to this group and to other groups to think about ways to really expand the data capacity in the county so that these kinds of analyses that Evan did of looking at the CDCR data by charging by race and a specific charge is something that's really readily available. And that's part of the reason this group exists, is that folks would want to know. And Evan, I see that you're 1 minute from maybe getting held in contempt in 9 minutes. So we will applaud you and thank you for being here. But I don't want to call from the judge. So you head off.
All right. Thank you, everyone. So nice to see you.
Thanks, Evan. So just in response to Jeff's comment, it is something that we've really identified as a huge challenge. And I know that our folks that do post-conviction work are already receiving a deluge of letters from incarcerated folks. And it's brilliant that there's been this huge expansion to look retroactively back at convictions. But the majority of those, again, that we represent in CDCR are people of color and will have cognizable claims. So I'll go to, I think, Ronell, and then Denise had questions.
Yeah, I was just going to chime in about the multiple levels of components to injustice, right? It's not just one. And it's good that, we focus or highlighted this one aspect, which is the courts itself. Things that I try to explain to individuals who are in the system, even now when I go in to talk to them prior to release, is about language, right? Not all of our participants or I would just say participants are versed in language, and some of the language in courts, jargon and attorney language, judge language, it seems to be a commonplace, but it's not always commonplace. And when I start talking to folks about signing documents for taking plea deals, and starting with words like forfeit, which is a common word, a pretty layman term, but doesn't translate well with folks who I work with in the system. And just the fact I have to explain to them, you've turned over your rights at that point. And say, oh, they took my rights, so I lost my rights. Well, you don't lose them. They're not, you didn't put them in another pocket or left them on the table before you left home. You've turned them over to the system, being awarded a court or what have you. So the court is important because I find a lot of folks in the system that I work with don't necessarily have a full understanding of what they've, pleaded to, or the sentencing even at times, what the charges may warrant based on, the actions of individuals committing crimes and not even knowing what they may be facing once they are arrested. So there's several levels, and we know it all starts at apprehension. Apprehending a criminal per se, or someone who may be breaking the law. There's several ways that can go. Appropriate charging, stopping someone unwarranted. It all begins right there, and from there it snowballs depending on the perception of the person arresting them. There's some minor things that happen, but then someone may have even more deeper or more serious charges based on the nature of their background or skin color. When we talk about the disparities, they're definitely real, and those are consistent. The things that happen in the system may be different, but the disparities still stay the same across all of those components. African Americans always lead the pack, even though they may be smaller in number as far as population. They still lead the pack in several areas in the system of justice or injustice. So I'm really glad that he shared what he shared. This is good stuff, that at least there's something on the books, because there's times when if there's nothing on the books, a person can be bombarded with all types of language that can be biased and skew juries or anybody else into thinking a person is one way when it may not necessarily be the case. But if you're allowed to use all kinds of unlimited toolbox, then you can paint a picture very easily. So this is good stuff, but it's just, like we say, scratch the surface, and many other areas that need to be addressed. So thank you, guys. I thank him for that presentation too, as well.
Thank you, Ronell. Denise?
Well, first, Ellen, I presume that you made arrangements for Evan to come and talk to us. And I just want to say thank you for that. This is really, really helpful information. And I did send a private chat to Evan, and I'm not sure if he got it before, but our office has a relationship already established with CDCR and DOJ. I have much of this data already. We've done some of these early analyses on the disparities in the pathway and the trajectory of justice involvement. And not to say that I can do additional analyses for any case that he has, but certainly we have some stuff that might help. And I'm happy to put you in that direction. I would also argue that maybe even an amendment to our office's data request with CDCR and DOJ might even be quicker than getting your PRA through all of those agencies. So just want to throw that out there from the standpoint of collaboration and sharing this data, because you guys shouldn't have to spin the wheel too.
Thank you, Denise. That's a really wonderful offer. I'll definitely connect you with Evan. I know, one of those pieces is when you're sending something to a mammoth institution like CDCR, even something that sounds simple of, doing a Public Records Act request can be very cumbersome. So I appreciate it.
Oh, and you have no idea. Patrice does, but even just getting that data and linking it, it's a process. So anyway, happy to support your office.
Wonderful, thank you. And do you know if your office will be doing any work with the local law enforcement agencies and their data? One of the things folks bring to me a lot on lower level cases is our clients feeling like the initial traffic stop was biased and should not have occurred and would not have occurred if they were not a person of color, right? So for us really to be effectuating the Racial Justice Act, it would be looking into that law enforcement agency and their traffic stops. And again, some of this is just, the reporting is just starting on
Exactly.
but is the ORJ going to be collecting from the local LEAs and doing any level of analysis? I see Patrice is.
Yeah, and Patrice, I'll let you chime in. I'll give you my thoughts right now is that we will wait for RIPA. And, hopefully the data will come forward. I believe the sheriff's office data will be available next year sometime. Smaller law enforcement agencies will be available in 2024, I believe. So we will start collecting that, and then we can link that with our local court and DOJ data. And go that route. But I think from the standpoint of standardization, that the DOJ already has that mastered. And I would much rather just put in a request there rather than going to local agencies in order to do that. The big issue right now, at least in my mind, is the DOJ public domain site is closed because they had that security breach. And I don't know if we'll get any of that again, but I would assume that we can go through similar process that we have for our internal rather than public domain data. So Patrice, did you have other thoughts on that?
I guess I was trying to follow your question, Ellen. You were asking if ORJ was doing.
Was going to engage. Yeah, engaging in analysis of, for example, the traffic stop data of law enforcement agencies in the county.
Yeah, I'm not quite sure how far into the weeds we'll get into some analysis of that specific piece. I know our ultimate goal is to be able to have access to data where we could do some linking, but the full scale breadth of like analysis and evaluation of that, I'm not quite sure yet if we're able to take on that task.
And I will also add that we've got some part of the reason why the data subcommittee moved forward with making a recommendation for the poorly named Policing the Teen Brain Project was because we were seeing significantly greater disparities at the youth level than we were in the adult level, which was an indication that there was some work that needed to take place with our local law enforcement agencies. Some of those disparities are higher in some agencies than others, but we're doing it at that level rather than at, kind of picking particular communities, so to speak.
Thank you.
Yeah.
Other questions or comments? I see that Alana Matthews from the District Attorney's Office stated in the chat, the RJ is meant to address systemic. I see you there, Alana. Do you want to comment?
Well, before Alana does that, let me just introduce her to everybody. That might be appropriate. I know that a few of you have met her, and I'll just introduce her in the proper way so that you guys understand who she is and what her role will be in the DA's office. And I guess since I'm talking, let me just say that, bias, I would say implicit and explicit, exists in every part of our system. And certainly, as we can see in the criminal justice system, it's not a surprise. But what I think I should say about that is that it's not acceptable. And I think that's why we're all at this table, really committed to continuing to do the work, as we are committed in the DA's office to work internally to ensure that every individual is treated fairly across the board. And a big part of that includes training as well. So we've brought in experts in the past, like Professor Henney, who many of you are familiar with from Georgetown, to train our office on bias and how it shows up in our work. And we've also taken the steps to proactively eliminate evidence and language that might be inflammatory or that might exhibit bias. But one of the most important things I want to tell you guys about today is that we've also brought on board, just as of this week, Alana Matthews, who's here with us today, as she will be working with this committee. She is our newest assistant district attorney and policy chief. She's a former director of policy and training for the Prosecutors Alliance, and also a professor at McGeorge School of Law, where she actually teaches implicit bias and the law, and is the director of racial equity and justice summer programs. And so she started in the DA's office in Sacramento, but has also had appointments from Governor Brown's office as well. So we're really pleased to have her on board, because it's really this kind of work. In addition to all of the other policies that she'll be helping us develop, she'll also be helping us to implement the training that we need to go along with those policies for our office. So Alana, I know you're here. Wave your hand, say a word, and let everybody, please give her a warm welcome to this discussion.
Thank you, DA Becton. Glad to serve on this. I've done a number of trainings for both prosecutors and actually law enforcement and public defenders offices. So this act is very important. And I did have a minor role in the new law that was just passed that made it sort of retroactive. So what I want to say, though, is that for those who are just now becoming familiar, it's really to address systemic bias. And that is anywhere within a criminal case that it can occur. And so I think the role of this board, or some of the partners at least, can be into educating the public. Certainly the DA's office has been very thoughtful and reflective in acknowledging, you know, this is unacceptable. So what measures can we put in place to move forward? And I think that that has to be a reflective or, you know, collaborative or kind of comprehensive approach from every actor in the criminal justice system, but particularly to community members, so that they are aware of that. You know, so many times it might be with a witness, an expert witness. It also might be with their own defense attorney. And so what does it look like to address the bias? So, you know, if in one case, the defense attorney is actually bringing the motion, in another case, where would someone, you know, be able to sort of seek that remedy? So I think there's a role for partners or the board to come together and educate the community and continue to see this as a systemic or look for solutions that address sort of the systemic bias, and not, you know, particularly target one sector, because it obviously, we know it may, some of the more common examples, or those that are used, are with law enforcement or prosecutors, or maybe even the judges, as one of the other members brought up. But to address it, you know, at the root cause, we really got to look at systemic solutions and how we can partner to move forward to address it all around.
Thank you, Alana, and welcome to Contra Costa.
Thank you.
Gigi.
Yes, I'm excited also about having someone like Alana here in Contra Costa County to do the work. You said broad systemic biases. Would mental health be included in that? Because we also see a disparity as it relates to individuals being criminalized for living with what is a medical condition, and that happening more often when they're a person of color or African American. Thanks.
So it is the Racial Justice Act. So, as you know, we certainly want to be aware of the statistics. So maybe if there is disparities in mental health diversion, you know, it just depends. And I'd be happy to talk with you, like, you know, maybe offline to kind of parse that out.
Thank you.
Again, it has to be, you know, couched in that way, or whether or not it's even recognized. a lot of times, and just having been involved in this work, that sometimes mental illness is not even acknowledged or addressed, or it might not be a mental illness, it might be a neurodivergent condition, so that we're not really directing someone to get the services and treatment that they need. So yeah, just unpacking, that's where my law professor comes out, unpacking all the different layers of this. Happy to discuss that, but it certainly can be included.
Thank you, because the bulk of African Americans living with severe mental illness get the primary services while incarcerated or in the most restricted environment. So it's definitely a part of the conversation. Thanks.
Yeah, and Gigi, on that point, I feel like it's almost looking at multiple systems, because folks often that we represent, who many of whom are people of color with mental illness, there's kind of that intersection, and maybe their sort of first break or their family's first attempt to 5150 them results in a law enforcement contact and doesn't result in a diversion into our behavioral health system, but results into entry into our criminal legal system. And so it's almost sort of zooming out from that first moment. And I know that's why you and others have been passionate about 988 and trying to look at that initial contact with law enforcement. That's kind of what we see a lot of, where we are aware that our clients have mental health issues, and we're also aware that that initial contact could have gone in a different direction and didn't. But we know that there are other folks from other communities whose did, right? And who were sort of pipelined and given, it was seen as a public health or a mental health issue rather than sort of pipelining it towards our criminal system. Anyone else on this before we move to our next agenda items? All right, thanks everyone. So item 5 is to discuss our progress on the Racial Justice Task Force recommendations. And Christopher, where's Christopher? I think Christopher will be presenting on this. There you are.
Thank you. Chris is fine. I'm gonna keep reminding you guys. That sounds so formal. It always is like jarring. I think it looks good on paper to put the whole name, but not necessary. I suppose I will share my screen. I think I don't see Tamisha on, but this is something that Tamisha brought up when we were, sort of huddling to plan for the agenda for this meeting, because this is the last quarterly meeting of the year. That it's always a good practice to sort of, look at where we stand, relative to what the charge has been. And the best way to do that is to look at the recommendations that we have. We've talked ad nauseum about the recommendations and how big they are, that many of them are not, recommendations that, you could necessarily achieve in a week or two. But are really big sort of long-term, long-standing undertakings that we'll need to continue to refine and to continue to work toward. But nevertheless, we do intend to make progress on them, right? And so just wanted to take a sort of a brief walkthrough of what those recommendations say, and sort of, as we go through them, talking about what the progress has been, where some of those things stand now, if any of them have been completed or are currently on pause for some reason, and getting any feedback or responses based on that. So I will just bring up the agenda. I think mine is already here. Yeah. Okay, so I'll try to keep this relatively quick, but please feel free to stop me if there are any questions or comments or concerns. So recommendation number 1, you all have essentially done by virtue of existing as a body, right? There's an RJOB. to oversee the implementation of these recommendations. It includes all of these members that were listed. To my knowledge, 1A, subcommittee reviewing local adult and youth justice data to identify and report on racial disparities. Obviously, we know that that we don't have all of the capacity and necessarily all of the information that we want, but there's a subcommittee that does that, right? And that they've been presenting that data and sharing the data that they do have for quite some time. Moving right along to recommendation number 2, with the goal of reducing disparities, form a committee to recommend countywide criteria and protocols for diversion, right? That's another subcommittee that you have, right? Under this, you see develop separate recommendations for adult and youth populations. So definitely some recommendations have been drafted. I don't know that we've broken them out necessarily by adult and youth at this point. Striving to ensure the broadest possible pool of eligible participants. We're working on eligibility criteria right now. However, there's a need for more information to understand the racial impact of any such criteria, and to make sure that we're not exacerbating the same issues that we're trying to address with that list in its final form. Striving to ensure that prior justice involvement does not bar a person's eligibility. I think that's something that is in the draft of recommendations that we have as well. Ensuring that inability to pay the costs will not prohibit participation. Here's where I think I'd ask for some clarification, because if I'm not mistaken, by the time that the Burns Institute actually began working with Contra Costa County in this capacity, there was already, I think, a countywide, initiative. I don't know if there was an ordinance or there's something that had been passed that was attempting to address these issues of fines and fees in a way that I think may have also had bearing on diversion costs to some degree. And I don't know what the status of that is, but definitely is worth figuring out as potentially a next step for diversion, as hopefully those recommendations and eligibility criteria get finalized. And then recommending as appropriate partnerships between law enforcement agencies and community-based organizations to provide services and oversight. I think that is ongoing in a number of different spaces, including CEF, with trying to build a community capacity fund as well. But I think that is up to this point for the diversion subcommittee. We've kind of been focused within the first 2 to 4 of these bullet points, and haven't gotten down to recommending specific partnerships with CBOs just yet. Furthermore, under this, you see, expanding the use of crisis intervention teams, mobile crisis teams, behavioral health assessment teams. And I think, there may be some information about, the progress of that, particularly because I know that, some local legislation had been passed to support, more of that sort of mental health, crisis response, apparatus. And then issuing citations and establishing non-enforcement diversion programs as an alternative to arrests, which is sort of the overarching point. So a lot of that, I think, is being undertaken right now. With the diversion subcommittee, there's just a need for some more information to make sure that we're making the right sort of impact before pushing this before the Board of Supervisors to ask that it be sort of enforced or enacted. Then data, right? Collecting individual level data on individual encounters for youth and adult systems and processes. Again, this is something that I think the data subcommittee has done, a lot of, great work, particularly, earlier this year and last year. to try to establish these things, including, asking for information from various agencies. I think one of the, actually, you'll see it here. This bullet point B speaks to all county agencies improving capacity for data collection and analysis, including expanding staff with data analysis capabilities. And that is not, I don't think that's specifically a recommendation that the our job can enact. You know what I mean? Like, I don't know that we can kick in a door and say you must start hiring more people to do this work. And so that's kind of the reason that, that particular item is sort of held up, and it kind of impacts all of this, but the work has been, underway. Those requests have been made. And it's clear that there are some, capacity issues there, some of which may be addressed with the ORESJ. And I know we're gonna, hear a little bit more about, the ORESJ and how it's coming along shortly. So the next couple of recommendations are for county support for local agencies, including integration. Again, you see a lot of common themes here. So this one's de-escalation and behavioral health intervention trainings in local enforcement agencies. And I would say here, I think that the work that the data subcommittee, at one point had taken up, and I'm not sure of the current status of it, around, some specific training for county, officers around youth interaction, youth brain development, working directly with youth and being trained specifically to interact with youth in a positive way, I think falls under this. I will pause if anyone has, an update, assuming I'm not stepping on toes as far as like something that may be forthcoming. I see Denise.
Yeah, what I can share is that we reached out through, it's got a new name, but it was the old federal earmark funds. We are waiting to determine whether or not that we get those funds. We should hear, I would think, the first quarter of next year, whether those funds are available. I have every reason to believe that we will get them. The program and our application was very strongly received. And so we'll see where it goes, but that's where it stands right now. And as soon as I learn anything more, you will probably hear me squealing from my office. So you'll know. So
Thank you.
A few more months to wait.
Thank you. So in addition to that, you see identifying funding for procedural justice training, utilizing the train the model. Now, I'm not certain, where, the county stands outside of the RJOB in terms of, local enforcement agencies, getting involved with procedural justice training. Certainly, I don't think procedural justice is particularly something that this group has been focused on among all of the other recommendations that we have right now. I know that there was, I think, an implicit bias training that was offered some years ago, to county staff, and I think made available, if I'm not mistaken, made available to the R job. And the R job raised its own, questions and concerns about that training, about whether or not it was coming from the right folks and had, the right sorts of topics covered in its curriculum, particularly in terms of anti-Blackness, as a focal point within, sort of bias training or thinking about racial bias, and so opted not to experience the training. I believe that training was still, brought forth throughout the county to, other agencies and offices, but not so sure on procedural justice. That seems like something that we should potentially take up next year, depending on where we get with all of these sort of items that we've already identified, where we're waiting, right? And where there's this patience necessary. If we can clear some of those things sort of from our plate, I think this may be something worth picking up, because for me, procedural justice kind of seems to function more like, what do we do with this information, right? Implicit bias a lot of times is, hey, let's all be aware of these biases that we sort of unconsciously bring to whatever we do. And that's a good foundation to start with. We just generally do not talk about what to do with that information from there, and how that should, alter or change our practices, some of our policies and protocols in order to reflect that awareness. And I think procedural justice sort of gets more to, that line of thought. I don't want to belabor these points too much. So you see here the County Office of Ed at number 8, County Office of Ed providing resources to incentivize school districts to explore, evaluate, implement non-punitive discipline practices in school. This is basically trying to respond to the school to prison pipeline. And this is also part of the work that the diversion subcommittee is doing with a lot of help from LaShante Smith and West Contra Costa Unified School District. There is, I believe it's attached, there's a plan for, first, before sort of moving forward with providing these resources or incentivizing school districts in this way, getting a handle on what students actually feel like they need in these spaces in order for any of those resources to be effective. And LaShante is helping with that. And I think we'll at least be able to show you, a brief sort of synopsis of what that plan should look like at this stage. And I see Lynn Mackey's hands. I will pause and defer to her.
Hi, I'm Lynn Mackey, and for those of you who don't know me, I'm at the County Office of Education. So it's just wanted to let you know two areas that cover these 2 points. Is one, a fairly large grant for us, about $6.5 million grant that we received last year. We're in the second year, and that's countywide to help support with mental health and PBIS supports throughout the Contra Costa County. And then also a fairly substantial grant that will bring a few $1 million to each one of the most impacted districts, which will be West Contra, Antioch, Pittsburgh, and John Sweat. And that will be for mental health supports, both direct and indirect services. So I can do a little write-up if you want, because it does address both these things directly. So I can send something to you, Christopher, that has a little more specificity if you want.
I would love that. Thank you.
Sure.
In the meantime, I think that plan for West County is moving forward. That is meant to be a pilot. Obviously, this is intended to impact all of the schools in the county. So we don't just want to do it at one school and leave it there. It's meant to sort of give us a sense of how to do this work and how to be responsive to the needs of youth as they lay them out. And so that basically covers 8 and 9, and Gigi, I see your hand as well.
Yeah, I'm almost always sensitive to most of the services being delivered in West County, when it's my understanding now that the bulk of youth that are going to juvenile hall are now coming from East County, so more the Antioch, Pittsburgh area, and hoping that whatever plans are in place, whether they pilots, et cetera, will start to focus more attention on the eastern part of the county. Thanks.
Well,
Real quick, if I can just hop in, Chris, because I totally understand what Gigi is saying. And I think I wouldn't necessarily call this a pilot, but really we're trying to do a kind of information gathering with West County, and some of the work had already been started. And so we saw an opportunity to expand it, especially because it was in line with the work we were already starting to do with the diversion committee. And since that work had already started, we're looking at it as being a template for what we can also do in the other districts. And so the goal isn't just to keep it in West County, but to also be able to use it so we can start gathering information from Antioch, Pittsburgh to figure out what are the needs of those students as well.
Thank you, Stephanie. So that, I mean, I think that basically covers 8 and 9, because certainly the point is not just to hear what students need and then not to respond with those behavioral health services as they identify those needs, but we want to make sure that we are supporting the process of getting services to them that are responsive to the things that they identify. That moves us to 10, 11, and 12 about establishing formal partnerships with CBOs to increase capacity for diversion, reentry, alternatives to detention, pretrial services, and programming. And that particular item is not necessarily underway because we're kind of focused on number 11, right? Establishing a community capacity fund to build the capacity of those organizations and to build the capacity of the community to show up in these ways and sort of meet some of these needs. And then identifying from there the organizations that, you know, might be best equipped to do some formal partnerships with justice agencies in order to increase capacity for all of the above. So I think right now, the Community Capacity Fund is what we tried to do, if you guys will recall, right? We tried to induce the board to discuss or potentially approve funding for a TA provider to help set up the fund. Basically, the CEF had essentially laid out what they thought the fund should do, who the fund should be for, and you know, at some point realized, or maybe not even realized, but simply acknowledged, you know, that the CEF or even the R job, right? It's going to be beyond the pale for this group itself to sort of host that entire program and to actually establish that fund. Now that we know what we want the fund to do, we need the expertise of someone who actually does that work to sort of set it up for us according to these concepts. So reached out to the board, you know, with that recommendation, and essentially the feedback that we got was that we need a more formal proposal that sort of sums up all of the above in terms of what the fund is for, what the technical assistance I think would be for before that could move forward. So right now, or at least by next week when we have the CEF meeting, you know, there will be at least an initial draft of something like that sort of proposal. And we'll go from there in terms of figuring out, you know, what details we might be leaving out, what things we might need to add or change before that hopefully goes back before the board for approval in a more complete manner. And so I think number 11 again sort of has taken the precedence. So I don't know that there has been much, you know, in terms of the R job collaborating with Community Corrections Partnership to consider increasing realignment funding. I think, however, now that I think about it, I'm not sure. I would rely on someone who would be more familiar, but I believe at one point this may have been a recommendation that was identified as something that had been done sort of outside of the RJOB space. And I you know, apologize if I'm speaking out of turn here. I see Patrice raising her hand to save me, and I'm gonna take it.
I'll throw you a life jacket. No, just kidding. Yeah, so the Community Advisory Board to the CCP has really for the last couple of years now, setting some recommendations, looking for some expansion in some specific service areas and wanting to see more investment in some particular program models to really meet some of the unique needs within the reentry population. So far, our reentry service delivery system is providing services more or less for a general population, but then there's some unique needs within that, right? So there's individuals with disabilities or co-occurring disorders. So the needs of those individuals versus those who are transitional age youth are all going to be very different, right? So we don't want to increase services just for the sake of having a greater pool of resources out there, but a pool that's actually going to meet the diversity of needs. That's what I want to say within that population. So actually on November 18th, the CCP will meet for its budget workshop to plan for AB 109 funding allocations for the next fiscal year. And during the September CCP meeting, the CCP members did, I would say, a very thorough job of going through the community advisory board's recommendations. And so there was robust conversations about next steps from that. So that conversation will continue into November and December. And we should see from there where there may be some potential expansions for the next fiscal year.
Thank you.
And also there are some actual CCP members who are on this call. So correct me if I'm wrong, if you didn't, if you know, I didn't. So, you know, there's definitely some overlap between both bodies, and others are welcome to respond.
Absolutely. We'll take a pause if anyone needs to jump in and be heard on this item. Going once, going twice. Jill Ray.
Yeah, so it's not on this item, but I realize I probably should have said something a while ago. I was just waiting for you to go through your presentation, allow the board members. So on the criminal justice fees, those were addressed for both adult and juveniles. So those were eliminated quite some time ago. All the county fees, not the other fees, but the adult and juvenile. So any other work would have to be done on a different level other than the county on those issues.
Right. Thank you for that clarification. So
one thing around the fines and fees, which could be good for us to have a presentation on next year. The Public Advocacy Clinic at Berkeley Law, they're actually doing some research around how that campaign has been going over the last few years. And I know that they've been checking in with different counties, including, I believe, Contra Costa, to make sure that fines and fees have actually not been collected. So it could be good to have them do a presentation on some of their findings that they've collected so far.
Yeah, that's a great idea, Stephanie. I would say, as someone who's a lawyer who's had to deal with fines and fees inside of the courtroom and has dealt with them on a policy level, it's incredibly complex because you have state fees, you have victim restitution fees, you have court fines. There used to be fees for our clients to do, a custody alternative or sheriff's program, and those don't exist. So I think there's been great progress in this area, but there are still, I think, some lingering legal financial obligations that our clients get, for example, to having to do a class for a DUI, alcohol sort of rehabilitation classes, which we as a society would want to see people in, are often so financially prohibitive that our public defender clients can't afford to get their license back, or classes for domestic violence. And for some of those, there can be fee waivers, for some there aren't. So I do think this is an area where, to Jill's point, there's been great progress on the county level and in stating, a lot of the county fines and fees would be waived. I know there's been great advocacy at the statewide level, but the system is rife with so many types of what they call LFOs, or legal financial obligations, that it's a little bit like playing whack-a-mole. So we do have great expertise at UC Berkeley, and they've studied all of the counties and looked at kind of the trajectory of the system. Are there tow fees on the front end for one of our clients who gets arrested and their car gets towed and then they lose their automobile? What are we talking sort of from beginning to end on a case? And is there any additional space for advocacy that this group could engage in? So I really strong second to Stephanie's good idea.
Yeah, and if that is the direction that we want to move in, I'm happy to reach out to them so we can get that scheduled.
Thank you. I'll be looking forward to that next year. I appreciate, the expert navigation, how you gave yourself that amount of time, right? You didn't say next month.
Nope.
Okay, so then there's 13, encourage the Superior Court to return to the process of jury selection, where juries are called to service to their local branch court for misdemeanor trials. I will say that when I first saw this recommendation several years ago now, I was very impressed. You know what I mean? That among the various different machinations of, a justice system, that the RJTF, took the time to recognize, this and its potential impact on outcomes, and to, call it out. I think my impression has been, especially in, speaking with sort of the reps that we've had from the court, that this, seems like, not as simple as, it says encourage, right? It says encourage, and that, may well be something that we can do. I don't know that, I'm not necessarily familiar with the forum by which, that encouragement might happen. But this also seems to me like, one of the recommendations that, as we clear some things from the plate, hopefully within the next, within the first quarter of next year, this seems like something that we should, really take a look at doing, if it's, still relevant, if this, if there hasn't already been some change to this end. Because at least having that conversation, or attempting to begin that conversation, seems like, a relatively speaking low-hanging fruit, right? That we can at least begin to have that dialogue. So I would highlight this one for next year sometime, unless there's any objection or any other discussion that anyone wants to offer in response to that.
I appreciate you lifting that up again. I think as someone that's practiced in Contra Costa for a long time, there was a move from having folks in their kind of local community. So if it were a Richmond case, the jurors would be pulled, if we're in the Richmond Superior Court, the jurors would be pulled from West County. If it were in Pittsburgh Court, the jurors would be pulled from East County. And there were some changes. I know it's obviously complex for the courts, and it's a very big topic of how to reduce barriers and how to get people to their jury service, and how to encourage that, and how to reduce barriers. I know, for example, San Francisco has started a pilot program of offering additional funding to jurors, offering to actually pay them. And I know they got some funding for that. But I would say from my perspective, having a dialogue with the court about ways that we can support ensuring really diverse jury panels that represent our communities in this county would be very, very welcome. And I see a hand from Matt Malone.
Yeah, I just wanted to say, if that's a dialogue, I'm happy to be a connecting point for Chris as we go forward. So if we want to start that discussion, that's I'm happy to be a part of that.
Thank you, sir. I didn't want to put you on the spot, but I appreciate, I really appreciate you jumping in there. No, we should definitely talk and figure out sort of what that process can look like next year.
Yeah, and I should say, I can't say anything about the, I know very little personally about the, it all predated me, and there were changes as was mentioned earlier. So I don't know what I can say in terms of what the, of how realistic it is, what the procedural stuff is, all that, but we can figure that out, and we could talk through it at least.
I look forward to having that conversation. Thank you so much. And then Ellen, since Matt so graciously stepped up, when the Superior Court was, referenced, I'm going to be looking to you on these next two, because I do seem to recall that at least one of these we were told had been, sort of already implemented in some way, I guess, in the public defender's office on its own, right, independent of the R job. I'm not sure which one, but 14 and 15 are hiring social workers to assess client psychosocial needs and link them to services, and offering civil legal representation to clients, including educational advocacy for youth.
Yes, thank you. And so on number 14, social workers, we have been adding social workers to our department and what are called client services specialists, which are similar to social workers, assisting our clients with connecting them with community-based services, including even transportation to those services, getting benefits back in place, helping folks pick up medication, and doing that sort of reentry release component. So as with everything, it's been really impactful, but has highlighted in some ways the need for some additional capacity, but it's been really helpful in assisting our clients both in custody through release, or assisting our clients put together pretrial release plans so that they can be in the community and can be, more successful, assisting our clients in authoring what are called alternative disposition reports. So maybe a psychosocial report about our client's background, some of their needs and challenges, and then talking to judges about what are the community-based services that would allow our clients not to be incarcerated, but to have other alternatives. So those are some of the ways we've utilized our social workers since this recommendation was authored. And we are bringing on 2 additional social workers through a partnership this spring with the Alliance to End Abuse, and they will be working with our misdemeanor clients who go through domestic violence court. So they are going to help those clients connect with different services, do trauma-informed care, work with them on ensuring that they can complete their court-ordered classes, and can help reduce some of the barriers that we've seen for that population. So we're excited about that pilot as well. And then in terms of the civil legal representation, for our youth clients, we have an attorney that's been doing educational advocacy for them in our juvenile unit, and he's been doing some really wonderful work with those clients, and specifically in our educational systems. Many of the children we represent have IEPs, need educational advocacy, have developmental disabilities that are perhaps unseen or undiagnosed. And so he's been doing wonderful work ensuring that they are able to receive the services that they deserve, and helping in the post-conviction context as well.
Are you saying we should cross number 15 out? No, I'm just, you don't have to answer that. It was just a remark. I see Jill's hand and then Gigi's hand.
I'll defer to Gigi since she's a board member. I'll wait.
Thank you.
Oh, well, I was just going to share that. Please don't cross it out, because a bulk of my time is spent supporting individuals' families, because when the individual is incarcerated, it's their family that's scrambling to try and get support for them, get them connected to services, trying to come up with a treatment plan to convince the judge or whomever's willing to listen, DA's office, that they should be released. So I just haven't felt like that holistic approach is truly being lifted up if the family voice is not being considered. And NAMI does a lot of that work. So hopefully it will be some opportunity for it to expand the circle to the broadest definition for family. Thanks.
Thank you, Gigi. Really quick before Jill goes, I'll just add to that, right? The way this recommendation is written, it does say either directly or through partnerships with community-based organizations. And, I'm not currently aware of CBOs that might be, so well positioned to take on some of that work and help to shoulder some of that burden. But if any emerge with that capacity, is definitely something that could be helpful in expanding the reach of that type of service. Jill?
Okay, so my question is to Ellen on that number 14. Ellen, do you have any sense if Cal AIM and the supportive services for the criminal justice population will help your office along those lines with wrap services and case management?
You know, I think it ultimately will. I would say right now, one of our main challenges is on those front end cases. And just to lift up Gigi's point, you know, Jeff Landau, who's here, probably could talk to us from the trenches, you know, that on Monday in our arraignment court, I think he represented close to 20 clients in, you know, just one day that were recently arrested, that, you know, our office was just able to meet with that morning, and that he was trying to offer, you know, personalized release plans to really each of them. So maybe I'll punt over to Jeff on how he feels like we're doing on the front end with our client services, and if we're able to really offer that holistic piece that Gigi was flagging.
Thanks, Ellen. Yeah, I mean, I guess I'd say it's my experience over the course of the 15 years that I've been with the office that there's been major progress in terms of how we look at what is full representation and what things are appropriate for our office to be advocating for. So I think just the general consciousness that the things that we're talking about, advocacy outside of just legal arguments in the courtroom and kind of the conditions of our clients' lives, that we're making more efforts in that, and the awareness, and there's been greater capacity with increased social work services in our office. And yeah, it's my experience still that there's a lot more that's needed for us to do everything that really meets our clients' needs. So that's to say that there's been really meaningful progress, but right, it's very common that I'm in contact with folks on a daily basis that are not connected to services that we know that are there. And it will take a real one-on-one, in-depth connection to really get through more than I just saying, go to the adult outpatient clinic in one of the 3 spots, and getting connected to case manager and payee and social worker and all that stuff. We'll take that sort of specialty in social work. So yeah, that we need it still greatly, especially since we have an awareness of how we can use it now. I think we've seen the returns from it when we do have that type of engagement. So yeah, long answer, but it is needed, and it's really helpful when it's there.
All right, anything else on these? Thank you all. Okay, the last few here. So under confinement, you see expand eligibility for pretrial services, increase pretrial services staffing, with a focus on reducing disparities and replacing the money bail system. And
sorry, I don't have any information about that, but I found something else. Do you want to know what is the
Oh, let her continue talking. She might give us the answers we've been looking for.
Well, see, as you can see, like my home speaker is very racial justice oriented. So as we start talking about these things, she thinks I'm talking to her. So I don't know that we have that we as our job have done much on this particular recommendation with you know, sort of being preoccupied with the others where work has been identified as underway, or you know, or you know, even pause. So I mean, I think this could potentially be another one of those you know, sort of items that we look at next year, particularly if we find ourselves still stuck in the areas that we may have been because of things that are outside of the sort of the purview or the control of our job, then this might be, you know, a place that we want to pivot toward. So I would recommend keeping our eyes on this. Number 17, expanding the current pre-release pilot to serve all individuals in custody. I think this is another one that I think at some earlier point may have been sort of identified as something that had already taken place, sort of independent of the RJOB, but I'm not sure. So if there is, anyone who could speak to the pre-release pilot, what that is, and if it's been expanded since 2018, I would love to invite you to do so now. Jeff?
I'm thinking this is related to pretrial services, PTS, and who's eligible for release. I'm not sure if I'm right on this, but that was my sense, is that, right, probation now has its own screening as a part of the arraignment process. And Gigi, you were seeing this in the courtroom this week, where there is a determination of whether someone might be released with a level of supervision from probation, even if the person's not on probation. And it is still the case that people who are charged are determined not to be eligible for a variety of reasons, the nature of the charges often being the case. And so I suppose that I experienced that still in arraignment calendar, where it's a situation, perhaps this person would have been a good fit, but given the charges, they've been disqualified or not eligible. So just the idea that everyone would be able to have consideration, and likely, if it is a serious violent case, the result of the screening will be that the person wouldn't be eligible, but that's not always so. And sometimes it's real old history, or looking more closely at the facts of the allegation, perhaps the person might be considered, but for a disqualifying general level at the beginning. So that's what I think that this might be about, and that it would still be valuable to consider.
Thanks, Jeff. Melvin?
Yeah, and I just want to say I have my director who was over pretrial services. And if you want to just jump in and just give a quick sort of update to the expansion and what we're doing, and maybe even talk about the sprinter vans and the mobile supervision of us now going down to the court.
Yeah, no problem. I apologize for my camera. I got really bad lighting, so you guys gonna get the milk dud presentation today. So I apologize for that. But Jeff, you are pretty much spot on in the sense that we look at every felony case in custody and we make a determination. Some of that's based on local rule that was decided what charges would be considered for pretrial release, and some of those will be disqualified based on charge. But we do screen every felony case. We write assessments for the ones that fit that criteria. We have expanded that criteria. We have expanded the unit. We are in full control of the arraignment calendar and going through each individual that's on for a felony and making those determinations. Probably in the spring of 2022, we were fortunate enough to secure 3 sprinter vans to allow us to do a better job of meeting people where they are, to work with our pretrial clientele, and also our post-supervision, post-conviction clientele as well, by serving the community better, by bringing our what would be traditional brick and mortar services in a building to the community via the sprinter van. So we've been able to serve people a lot better that way and show up at the arraignment hearings. Sometimes it's depending on when they're released from sheriff's custody, make contact, but also people that are showing up for other probation matters to resolve things and do everything we can do in a brick and mortar building in our sprinter vans. So I'll stop there and entertain any questions.
Okay.
All right.
Thank you. Thanks to everyone who contributed there. The last few here, basically 18 and 19, that kind of became the push, or at least the basis for the push for the sheriff's oversight, that took a different form, once it hit the Board of Supervisors. But, for the record, right, this is where that language comes from. It's a little different, but this is sort of what that was all based in. Of course, once the legality of that was determined, it's crossed out here because it was not determined that this would necessarily be something that would be a lawful practice. You had some legislation clear that up. This body sought to bring it back before the board, and that resulted in action that was not exactly what the specific ask was from the board, but that was this group sort of spearheading that push, and to the extent that residents have been heard about it, or community members have been heard about it, and whether they're satisfied or not, or wish to to continue to raise the issue or not. This is the Racial Justice Task Force's recommendations, which this body is responsible for implementing, is the basis for that ask. And right now this is where it stands. And I'm sure that if I stop and ask for it, there will be all kinds of commentary on that, and I don't blame you. But what I would say is, the last one I think we kind of covered, 20 all county staff participating in and completing implicit bias training. Again, I think implicit bias training has been made available throughout the county. I think that's something that has been done outside of or without, the need for much help or input by the R job. That seemed to be the case sort of when we referred to that earlier in the document. So I think that one has been, at least, the training is made available to everyone, and there's the expectation that all county staff are going to participate and complete, to my knowledge. And certainly if anybody has any more to say on that, I would invite you. In the meantime, I see some hands, but this is essentially the end of this document. So before turning it over to Cheryl and then Gigi, I would say, again, I think this is, a worthwhile practice to look at, what the work is that we're responsible for, and to think about where we have progressed, where we may be stuck, where there may be a need to pivot or to change. None of these things are necessarily being crossed out or checked off as done at this point, because so many of these recommendations are, huge and will take a lot of time and energy to get done. But for many of them, there has been some significant work. There has been some progress, even if, at a certain point, things may slow down. And I think that's a testament to the work that this group is doing and will continue to do. Certainly what our goal is to, at some point, get to the point that we are checking some of these things off and crossing them off and moving on to the next thing. But we know that that's not always going to happen, within a short period of time, and that many of these projects will be ongoing. So always good to check in, and I will start with Cheryl, and then we'll go to Gigi, and then Patrice. I see your hand as well. And I think maybe I can stop sharing it.
I usually don't parse my words, so I'm not even sure why I'm doing it right now, except the last two items that are struck out are items that the community felt very strongly about. And regardless of the other things that we have accomplished, which I think we have accomplished a great deal, those are still things that the community has felt very, very strongly about. And we brought them back onto our agenda and into our charge because of the community's input and the community's compelling want to make sure that there was accountability for the continuing disparities that we see in the criminal punishment system. And so I personally am not willing to just move forward with, because there's a way somebody has voted it, and so we're just going to leave it there. I think that we have an obligation to continue to push for these accountability and oversight. The state is giving us that the original argument is that there was no legal means for establishing oversight, and that is now been taken, that argument has now been taken away. And the community has asked for it, they've pushed for it, they've come to this meeting and requested it, and it is our responsibility to continue to ask for it. There is no argument that I've heard yet, and either in this venue or in the public protection meeting, as to why we cannot have this kind of independent oversight. So I still petition this body to put this back into discussion. And if that means we have to wait for another sitting of the Board of Supervisors, then that's what we do. The other thing was being able to issue a complaint or issue a grievance that does not require the approval of the people who are harming you. I don't understand why that's not an issue. If someone is harming you, you shouldn't have to get the approval of the body of the people who are causing you harm in order to file a complaint. That does not require rocket science. And so it is our responsibility, again, to bring forth their request in order to protect the community. And so I am here as a member of the community, and I'm sitting in a seat representing the community and community-based organizations, representing the Racial Justice Coalition, and representing that gap that we continue to see. And so that is where I will continue to speak out and ground us in the fact that we do not see a reduction we might see a reduction in people and numbers, but we're not seeing a reduction in the disparities. And so we need to continue to advocate for this community. Thank you so much.
Thank you, Cheryl. I'll just say real quick that the CEF tried, I think we made 2 attempts to hold space to hear the community on that because there was an issue with the link. And it's to the extent that community folks showed up in either space, you are reflective of what they shared. Gigi.
Right, I wanted to ditto what Cheryl said. And also around the, I guess you call it racial bias training or implicit bias. I just go straight to the point. Racial bias training is definitely needed. There was some participation from supervisors when you did your presentation, Mr. James, which I thought was excellent. It can kind of help people better understand. And then we went into a Board of Supervisors meeting where it was obvious that they're not that understanding. You got to just keep training people over and over again and making it personal to them. So there are some trainings that I think could get lead decision makers closer to where we need them to be, but we still have a very long way to go in this county to reduce the disparities that we see through all of the systems. I am unapologetically spoken to who's most harmed, and I come into disagreement with that with many people, but the facts are written down. We saw today in the presentation. So hopefully we'll continue the work of this group to get appropriate training we needed. And if you can share, I'll share what you've shared with the Board of Supervisors so we can have finally a discussion that's fair and honest about what white supremacy, which I would never call anyone a white supremacist, but sometimes it's demonstrated that we have a culture of that in this county. Thank you.
Ooh, put me on the spot with some structural well-being. I would love to do some structural well-being work in this space. It's just the way that it's structured with the subcommittees as opposed to the whole group meeting to do that, it would, be cumbersome unless we're going to have a bunch of special meetings, but it's something that, I'd be willing to get into. Thank you for that.
Can I ask you, in your work, do you ever make a requirement for those making the decisions to take a training before you come into the space? Because sometimes you do have to start at the very top to influence change. So that might be a policy that's brought in through some of the new policy workers that we have coming into place in order to be in a particular position, making decisions, especially that impacts people's life in such a strong way. There should be some training that takes place. Thanks.
Yeah, so what it looks like is, there's a certain way that in a lot of cases we implement the structural well-being approach that does require, executives to show up and be willing to do pre-reading and all of this other stuff. And then to come in and do all of these sessions, and actually show up to all of them. You can't send a surrogate, like you have to be there, and sort of go through the process. So that is something that we have done, usually with jurisdictions who are familiar with our work, familiar with the approach, have reached out to us to say that they want it and that they're taking it seriously, which kind of, eliminate some of the other kinds of issues that otherwise might come up. But that is something that we've done. And Patrice, your hand was up.
Yeah, I forgive me if I missed it. Number 17 that talked about expanding the pre-release pilot to all jails. I just wanted to acknowledge that is currently happening with the good work of the game plan for success, actually under Office of Ed, and they've been really great partners. And prior to COVID, they did an awesome job of collaborating with outside CBOs, welcoming them in as they hosted orientations and things of that nature. They share information with us. They've been using a risk needs responsivity, an R&R assessment tool that gives us a lot of information to see what are the actual needs of those in custody before they are released. So they've been doing some incredible work, and so just wanted to uplift that is in place.
Thank you for acknowledging that, Patrice. Really appreciate that perspective. Cheryl, I see your hand again, and then I'll just remind everybody really quickly, we have 52 minutes to get through everything else. Well, 51 now, according to my clock, that's on the agenda, so.
Just really quick, I wanted to say something about the training, because we talked about this before, and I don't think we ever circled back to it. And you mentioned the training and why we didn't go through it, and we haven't cycled back to it. And there was a very concrete reason why we did not agree. And I know I was one of the ones, and Ms. Tamisha and Ms. Gigi and several of us objected to the trainers. And that's why we didn't go through with it, that bias training. It wasn't because we didn't think that the training was necessary. We objected to the trainers that the county had already paid and selected as an all-white firm, and they were former officers or something. And that was the objection. And I think that is very important, that you don't have people who are part of the system as all white women training us on bias training. And I know we're being recorded, and I don't care who hears me say it. There's nothing you can tell me. There's nothing you can tell me about being a Black, Latina woman, API, a person with disability, from looking at you from the sidelines. And you certainly can come in here and try and tell me about your empathetic view of doing that. And there was no Black men, there was no Black women, there was no API women, there was no, and you had like one Black man that they were hiring as a consultant. You can talk about these kind of issues, and none of them had been in the system except for arresting people. So don't talk to me like this. That's what our objection was. So if we're going to be real in this space, let's be real in this space of what the objection was. That was the objection. There was no one who was formerly incarcerated. There was no one who was impacted by the systems. There was no one who had felt the harm of being invisible, unseen, unheard, and who was harmed by the actions of the criminal punishment in the criminal legal system. So why are things getting worse instead of getting better if we are doing so terrific work? We're doing so terrific work, then why do we still have these large disparities? We're doing great work on paper. But we still had a Board of Supervisors meeting last week that was abhorrible. It was abhorrible. They were yelling and screaming and hollering at each other. And there was some horrible language being thrown around in that meeting. No one was listening to each other. And yes, as a matter of fact, everybody's definition of white supremacy was probably factually correct. Factually correct. But in practice, it was not. It was not. And that was the problem that we see. And that's the problem that we have when we're talking about racial justice in the criminal legal and the criminal punishment system. And that's why we continue to see little black brown bodies and little black and little brown bodies being seen as unimportant and devalued and funneled through this system. And that's what we need to continue to talk about in this space. And that's what we're supposed to be doing to make a difference. So yes, the data subcommittee and the community education education engagement fund and the diversion subcommittee, we still have a lot of work to do, and we've done a great job so far, but we have a lot more work to do if we can't even get the 5 supervisors to have a civilized conversation during the meeting on this. This is what I want to say, because we couldn't have them, they couldn't have the conversation just for the Office of Racial Equity and Social Justice. That is supposed to have a say in what we are going to do as the Racial Justice Oversight Body. So how can they even hire a person to do the bias training, Christopher, that the kind of training that we need you to help us oversee? Because that conversation was embarrassing, and it was disappointing, it was harmful, and it was offensive. And it wasn't just from one side, it was from all of the people who were participating in that conversation. Almost all, I will say, almost all. So yes, there's a lot more work to be done. And I just wanted to make sure I said that, because anybody who didn't attend the meeting or watch the meeting, you probably should. So you'll know what work that we still need to do here on this committee. Thank you.
That was it for me, Ellen. So back to you to move us to the next agenda item.
Got it.
Thank you, Cheryl, for sharing everything that you just did.
Thank you, Cheryl. And does anyone have anything else on the recommendations or on Christopher's presentation before we move on?
Maybe I would just propose that this is something that we do annually. I mean, I think, Chris, you had said that it's worthwhile to do from time to time, and maybe to just kind of more formalize that proposal, that not necessarily we need to take a vote, but that it's something that we would intend to do moving forward, to have this at kind of at a minimum annual check-in.
I agree, Jeff, and this kind of came out of also the idea that our membership body changes, there are folks onboarding, and do they really have a roadmap of, you know, where we've been, what our mandate was, what our goals were, what we've achieved, and what's outstanding. So I think it is something that should be visited with regularity as well. All right, with that having been said, we're going to receive reports from the subcommittees. So I'll first shoot it over to Stephanie Medley for our diversion subcommittee report.
Thanks, Ellen. I mean, actually, Chris talked a lot about what my update was going to be with the diversion committee. So I'm not going to, talk too much more about that. Just so folks know, LaShante and I will be connecting so we can start figuring out what a timeline would be to get more young people involved in the process of this listening session. That's a huge part of what we're trying to do, because we don't want this to be adult-led. We want it to be youth-led. So we'll be connecting, and hopefully we'll have a plan before the year is out. And then I think the only other kind of update that did come up, we've been talking about the criteria for diversion, and Simon did mention some of the efforts at the DA's office around data collection that are happening. And so we're hoping that we can potentially, and I think a report from the Vera Institute. So we're hoping that with some of those data collection and evaluation pieces that are coming up, we'll be able to use that to help make a more robust kind of criteria list for that we can present for diversion recommendations. So that's it.
Thank you, Stephanie. And I'll go through all three reports before we ask for comments or questions from either the RJOB or public comment. So next is Jeff Landau on the Community Engagement and Funding Subcommittee.
Thanks again, Ellen. This is attachment 5 to our packet. And if you're, I think, page 36 of 92 from this agenda packet, and talking about the experience of the last quarter, I guess, looking at that first bullet point is to say that we welcome, and I think it's essential that we do receive and respond to community feedback, things that are happening, even if they're not on the agenda beforehand. That's the nature of public comment, right? And that being community engagement and funding, just by its very nature, needs to be responsive. I mean, all of the subcommittees, but perhaps even more so, just in that it's a place for the community engagement. And that has been crucial. It's led to our taking action on things like sheriff oversight continuing, because we're responding to what we're hearing. And also there was a lot of energy, attention, advocacy related to closure of the Orrin Allen facility. And that I think has some, I guess, maybe tension or at least relationship to the things that are our continuing items work plan. So I guess it's accounting for that as we move forward, looking at these subcommittees and what capacity is relationship to our intention specifically for the Community Capacity Fund or our Building Community Capacity Initiative. We're working on exactly what the language will be, but that's a long-term project, as is the Youth Advisory Council. And we've made steps in those projects, but it's also true, if I just look back at the subcommittee meetings for the last several months, a good chunk of the time has been spent on priorities and issues other than those. So I guess it's our recognizing that we're doing work that's still consistent with what is our work, but acknowledging we need to have either a separate space for some of that community input within the RJOB, or a kind of a calibration within the subcommittee of how we apportion our time and what our goals are. I'll say that you see those other bullet points, that a good bit of comment happened in August. While we were not able to have that meeting formally, it was just an event that occurred, that there was a good bit of feedback, and then we incorporated that into our meeting notes from the following meeting in September. And yeah, at this upcoming community engagement and funding meeting, which will be next week, and it'll be on Thursday, right around the same time, that we'll have time and attention going toward, in particular, the community capacity fund and what that proposal will look like. So I'll just encourage folks here to, if they have time and energy, to be there for that part as we're shaping that next stage of the process. And I think that's the update that I'd provide. Of course, happy to respond to any questions about what we're up to.
Thank you, Jeff. And we'll turn it to Patrice with an update from the data subcommittee, and we can take questions.
Yeah, so for the data subcommittee, we've been on a bit of a hiatus for this last quarter, given some of the constraints around some of the data requests and analysis, and really trying to figure out where will be the placement for a lot of the data work that's needed. That's been discussed not only within the data subcommittee, but then it's also bubbling up in other subcommittees as well. And so as we're kind of put on this hold, if you will, the subcommittee has not met, though we have had leadership change. I think we reported last time that our new subcommittee chair is Shayla Bonner, who I believe is on. Where we last left off in terms of where the placement for a lot of this data work would happen was during a previous PPC meeting, where there was a great concern about when we would actually get an update on the Office of Racial Equity and Social Justice, and identifying that as probably a really great place to better serve the our jobs data needs. We'll have it is on the agenda today that will obviously give time for folks to talk about that update, but I think given what we've heard, there still may be some question marks around what whether or not that in the development of that office, if it will still be a place, or if there's some other alternatives that staff would have to look into. So all to say, the update is that there is no update, and that we haven't met in a while, and we're sort of still on this kind of holding pattern for the time being.
Thank you, Patrice. So questions from members of the oversight body for Stephanie, Jeff, or Patrice? Jeff, you're on mute.
Thank you. Not a question for myself, but I did want to ask about the data group, and kind of just in all of our public consciousness, I guess, that, well, now there's this new Odyssey system that the court is using, as opposed to it used to be Law and Justice is what it had been called. And now Public Defender's Office has this DBK, which is our data management database, and we used to be all paper largely. And I'm wondering if that's changed any of the work that's happening with the data group. I mean, understanding that there's been a bit of a hiatus. Maybe it's me just putting that out there in terms of this group and awareness that maybe that changes our capacity and what could be asked for. And it may be known to everyone already, but at least in practice in the county, it seems like those are material changes in terms of what could be provided and asked for. Just flagging that as part of the discussion is perhaps maybe we have more capacity than we used to make these requests and tailored things like that. And that, right, it's a lot more is automated now than it had been.
Anyone else? Or Patrice, did you have anything? I don't know if your subcommittee has met and talked about any of those different case management systems.
No, as I mentioned, been on a hiatus, so those items haven't been brought up for discussion.
Great, and I think what Jeff's referring to is we have a case management system called Defender by Carpel that was implemented last October at the Public Defender's Office that we're still working to customize, but we're sort of transitioning to paperless, and it does give us opportunities to leverage more data than we have in the past when all of our clients' information was contained in paper files, and that the county acquired that system as sort of a twin but separate system to the DA's system, which they also run on a Carpel, a prosecutor by Carpel platform. And I know they implemented theirs a few years back. And then the court has a separate system called Odyssey that they implemented in April. So these systems, I think, for all of the departments are relatively new. And I think probation is going to be going through something similar moving forward. So there may be opportunities with different stakeholders in our criminal system to talk to them about what kind of data could be leveraged from these systems. Other questions or thoughts from the oversight body? And then I'll turn it to the public. Okay, I'm not seeing any hands. Any public comment or questions from members of the public for the presenters? Scrolling and not seeing hands. I'm hoping I'm not missing anyone. Oh, Jane, I see your hand. Jane, do you have a hand up?
Sorry, I'm on my phone and I am not too quick here. And just a very brief thank you, particularly for that wonderful presentation about 256 and its predecessor. There's a tremendous amount of interest in this now. I also want to appreciate that Ellen has invited me to share it, because I did a lot of lobbying with some of the statewide groups who did co-sponsor it. And of course, inside there's tremendous interest now that it's retroactive. So that was just outstanding. And I really appreciate what has been said, and will not take the time because many of us have spoken on this before. But Cheryl and Gigi pointed to the big elephant in the room, which is the oversight of the sheriff's office. Obviously, we are still going to continue to fight for that. And we are still going to continue to fight for better funding for the public defender's office to get those social workers. It was a fight to get a couple more, and we will continue to fight for more that we know are required. So that's it.
Thank you, Jane. Anyone else from the public? All right, with that, we will move to our next agenda item, item number 7, discussing updates from the PPC, the Public Protection Committee on Racial Justice Oversight Body Matters.
Yeah, I think I should take this, at least the first bullet point, which was just a draft of a form letter for you guys to use when you want to invite the PPC and or, the board, as it were, into these spaces, so that if you're having that conversation, there's been a lot of talk in the last few months about sheriff's oversight. You guys, for all of the many discussions that have been had in these spaces, right, that most of that was not, said directly to, anyone who was considering it before action was taken. And so we want to try to formalize a process by which you keep that from happening going forward, right, where you're able to actually be directly heard and all of your context and all of your points and questions and so on and so forth are directly heard. So I will share my screen quickly. Oh, I should have flipped to the page before I did this. I'm sorry. 38. Maybe not 38. All right. Essentially, this is a draft that came, here it is, from, it actually came from Becky Vashiki's, the letter that she used for the DA's office. I just took that and sort of adapted it to make a form letter officially requesting the presence of PPC members or others in this space. You know, so you'll need a corresponding agenda item probably when you want to do this, right, to talk specifically about whatever you're proposing. And that way it's not sort of in summation or at an end of the year report, but in real time, you're able to have a direct dialogue with the folks who ultimately will make the decision. And so they can hear directly from you to the extent that community are able to participate in these discussions or to attend, right? This all happens sort of in advance, you know, probably with a motion to, you know, move one of these forward and to edit or correct the language as necessary and then to send that. So there should be, you know, a good advance notice that, you know, the next quarterly or whatever it is going to be the one that they will attend. So that, again, those voices can be directly heard in this space. So just trying to get a feel for what you all think of the language here. As is always the case with any draft that I've ever shown you, I am not taking it personal if anything needs to be changed. Like, this isn't meant to be, you know, a perfect stab at it. This is just meant to sort of get the item before you and see what you think and see what edits and revisions we can make, and how folks feel about maybe proceeding in this way when there's a recommendation or any other action that needs to be taken up from the R job up to the board or up to the PPC first, and then eventually to the board, if this is the way that you go about engaging that process.
Does anyone have thoughts or feedback on this? Jeff, Gigi?
It's so small, I can't see it. I'm sorry.
Well, that is hopefully something I can correct shortly. Is that better?
Sorry, Jeff, I'll go after you after I read it.
Sure. Really, my thought feedback was to ask Jill, and I'm not sure if we have any other supervisor, Alyssa, just a sense of if there are existing models for this that you found to be best received, effective, basically when there's a subcommittee requesting presence. This format seems appropriate to me, and it's succinct and it makes it clear it's an official request, but I don't know if there's also an existing model that has worked that you might propose, but I'll just put that out there.
Elisa, do you want to take this or do you want me to take it?
Let's see, I think my camera's on. In my 6 months with Supervisor Burgess's office, I have not encountered this, so I can't tell you for sure. However, this does look like a good form letter to me as far as opening up that door for dialogue and engagement.
So I'll piggyback on what Elisa just stated, that normally you wouldn't call the PPC to an advisory body meeting, but you certainly can request to be on the PPC agenda to have a discussion about something, whether it's a yearly update or whether it's a specific issue that you would like discussed at the PPC. And oftentimes, like other advisory bodies will send letters to the Board of Supervisors saying that we voted and we would like you to support XYZ, whether it's a piece of legislation or something in the county. So that would be the normal process for something like this. So that's just my 2 cents.
If it's my turn now, I would say, can we strengthen it by saying from feedback from the community, like we represent a voice, like I represent the faith-based voice. So it's not just this body who's wanting their attendance. It's community members as well who would like to see them attend. That makes sense?
Absolutely. And I'll just add, I think the reason, okay, so, and Denise adds that the phone number on the letter is no longer active, so we'll make sure we get that tightened up as well. In response to, I think, so first of all, Gigi, I appreciate what you just shared, and I definitely do think that would strengthen it, right? That's an easy parenthetical phrase, you know, set off with a couple of commas that we can stick in there that I think would be the right thing to do and would be helpful. So definitely we'll do that.
Thank you. Then it would be my role to get other faith leaders to come and speak up. So thank you.
Good. If I'm not mistaken, so the reason that at least the letter is drafted this way and with this sort of approach is because I think in response to sort of the conversations that we've had in the past about, you know, trying to open that direct dialogue between the RJOB and the PPC, I believe, you know, the message that was shared in this space was that they are open to invitation from us and hearing from us in that way. And so this was, you know, sort of drafted in response to that. So if they're open, if they're willing to show up and to attend a meeting, you know, to hear, you know, what it is that this group is saying, or, you know, when there's a recommendation, then how do we enact that? Like, how do we go about sort of formally getting that on the record? Because we certainly appreciate, you know, that openness and that willingness to engage us in that way. So that's sort of where the idea started for me. And I think, you know, the rest of the folks in this group, and just trying to make sure that there's some record of that and some way to formalize that so that it actually moves from here to there and vice versa. Cheryl, well, Jane, I don't know if your hand is okay. I guess it's not. So Cheryl, I'll defer to you.
Yeah, maybe I misheard them at one of the PPC meetings, but similar to what you just said, I believe that they invited us to invite them to the meeting. So maybe my ears was lying to me, but I'm pretty sure that's what they did. So
Yeah, that was my understanding.
yeah, pardon me?
Just said that was my understanding as well.
Yeah, I'm pretty sure that's what they said at the meeting. So I get that in general, we go to their meeting, but I'm pretty sure that what they said that they would, you know, they would entertain that invitation. And the other thing is that I know that generally we put all of these on the side of this letterhead. We have all of these justice involved things, and then we have community at the bottom. And I would like to not see that. Personally, I would like to see community lifted up. Put it in the middle, mix it up, something. But it's something about seeing all of those justice people and then putting community, as if community, those in the community are less important in this process of racial justice oversight than those in the justice system. So somehow we need to figure out a better way of representing who is on these oversight body. And I think we've had this discussion before about that.
Thank you, Cheryl. So I think what Gigi just suggested, what Cheryl just suggested, as far as the names, changing the phone number to the correct one, and making sure that the information is updated. You know, those are all the changes that, you know, I'm hearing so far. Those are, you know, really easy things to fix. And, you know, either gonna make a note to self or come back to, this part of the video and make sure that those things are done before you see this again.
Thanks for your work on the letter, Chris. I think it's gonna look really good with that feedback. In terms of the 2023 Our Job membership, are you gonna be the one presenting on that? Patrice.
That would be me. Hello again. In just the last PPC meeting, that was October 24th, PPC members had an opportunity to interview a whole slate of applicants, to include new applicants as well as many of our existing community-based representative seats whose terms will be expiring at the end of this year, but are seeking a second term. In total, we had about 17 applications. And for those who were present, the PPC recommended the following folks for board approval to serve in the respective seats. Shayla Bonner and Melvin Willis, who were the two applicants who were nominated by the Racial Justice Coalition. They would be serving in seats 1 and 2. Ronell Ellis and Michael Pearson serving in seats 3 and 4. Those were individuals with personal experiences in the criminal justice system. Seats 5, 6, and 7 were the applicants that were nominated were Ianon Burrell, Alicia Jackson, and Cheryl. Cheryl, correct me, because I think I said your last name incorrectly last time. Is it Saduf? Saduf? I'm jacking it up. Saduf, thank you. Okay. And these individuals will be representing seats that are CBO representatives that work with Justice of All Populations. Gigi Crowder for seat 8. Faith-based organization representative, and then seat 9, Stephanie Medley as a CBO representative providing services to school age youth. Now, following that, I was corrected and I got a couple of calls and emails from folks who existing members who were in fact, though they were absent at the meeting, were in fact still seeking interest in sitting on the oversight body. So I just shared this information with the CAO's office, as well as Supervisor Anderson's office. And there has been some discussion, as it was discussed actually during the PPC meeting, that there were so many great candidates that it is really important to start looking at forming alternate member seats. So what has been discussed sort of in the background is preparing a language in the bylaws to make room for those alternate member seats, and to ensure that for those that were nominated during the meeting, as well as some of the folks that were seeking another term, to see whether they will be a full body member or an alternate member seat. So there's still a lot more work that needs to be done. We'll need to contact County Council about language and the whole shebang. We were hoping to do this as quickly as possible this month, but it's looking like it might still be put on the November PPC meeting agenda. So just know those kind of things are sort of coming together at one time to be sure that a little bit more availability is made for such a rich group of candidates that were made their interest known in participating in our job. And that this is no different from what we saw even to fill the first two, the vacant seats, seats 8 and 9. We had a tremendous amount of interest in that as well. So we'll be doing the work to make sure that we can at least structurally make those adjustments where possible. And I'll open it up for any questions that folks might have. I see Stephanie.
Thank you. I know we talked about this earlier in the year around onboarding, because we do have several new people that are coming on. And I think would also just be a good refresher for some of the folks that are returning. But what did we decide as far as onboarding for new members?
Yeah, so I listed a few documents that I could send to folks. And then because this came up before this iteration of, what's going to be a bigger influx of new members, was willing to or spoke to willingness to get with folks individually to, sort of have that conversation. To your point, Stephanie, about refreshers, or maybe, doing something like this for a larger group, it may be that we need to make space on the next quarterly agenda to do some of that. Because if we try to do it, in groups that are too large, right, we'll run across some quorum issues anyway. So I think, we may want to take some time, and that may be, I don't know, it may be a yearly, January, not January, but yearly first quarter meeting practice, or, as often as, there's a mass influx of new membership. But I think, just sort of going through the recommendations, the work plans, and maybe some of the slides that we've used in the past to sum up what the work has been, and sort of talking folks through those things. That's definitely something that we can do. Looks like we'll need to do it in mass and less on an individual basis in order for it to be a refresher, or to sort of reach everyone that will need it. But that's something that I think we can definitely do on an early quarterly meeting next year.
Yeah, I think it would be important. So because, I've been involved with first the task force and then the oversight body. And so, there's a lot of historical knowledge that I have, but coming into this and not knowing, kind of what's been happening, or even knowing how to proceed, it can be, I think, that also it causes kind of like anxiety too, and even participating on these different bodies, right? And so, and it can kind of be daunting, especially when you're hearing acronyms all the time, and just different things kind of constantly changing. And so I think it would be important for us to ensure that we're building the capacity of everyone that's participating on the body. I think that's important for us to do. And also just building like capacity around expectation for everyone to participate on the body and in different committees.
Chris, do you have anything additional on membership? Or Patrice? Any other members of the body or the public have any other feedback on the membership conversation?
I agree with Stephanie.
Thank you, Cheryl. I agree with Stephanie also. I think having us build something like this just into the structure, acknowledging that folks are going to need that onboarding. And I don't know if it's even an onboarding and recruitment subcommittee or if it happens in our general meeting. I think there's value potentially to both, but we really owe it to the folks that we're bringing on to make sure everyone's having the same conversation with the same information. All right. Oh, Gigi.
I've seen a buddy system where someone from already sitting on there educate a new person coming on. Not everyone is as vocal as I guess, because I know I talk offline with some people who are here and they have great things to say, but they're silent when they get here. So that would be useful.
That's a nice idea. A little mentorship. All right. Okay, our next item is the ORESJ, the Office of Racial Equity and Social Justice Planning Update. I will pass this to Chris or Patrice.
Okay, so it was added to the agenda to give space for folks to respond if you attended the Board of Supervisors meeting. This was on, oh gosh, was this the 25th? Yes, October 25th, where the Board of Supes heard an update from the Core Planning Committee on the structure and staffing and all the intentional community engagement work that led to the report that you see attached to this agenda today. As it was referenced a little bit earlier, it was quite a robust discussion, I would say. And so we just put it on the agenda to allow space for folks because as you all may recall, there were a number of different items our job related that was recommended or suggested to be placed under the umbrella of the Office of Racial Equity and Social Justice. So you all are welcome to talk that through a little bit more or have any reactions to share for those of you who attended. And I see Jill has her hand up.
Well, I was just going to state that just in case anybody in the room doesn't know, is the Board of Supervisors did approve the recommendations by the core committee to lift up that and establish the Office of Racial Equity and Social Justice. And so it's moving forward, it's funded, and we're excited to see where it goes because it could be a great place for data analysis, which has really been the concern with this group in the inability to do that. So we're super excited to see that move forward.
Jill, when will they start? Like, when will there be a job announcement or anything going out for the co-directors?
That I don't know, but I do know that the CAO's office is working on it. So I can find out and get back to this group as soon as possible. I know we've been eager to have this moving.
Thanks.
I know we were particularly happy to see that there was a data analyst position placed there. We're like, all right, we already got something for you. And we can share screen in case that there folks want to see what the proposed staffing plan or office structure will look like if that is of interest to folks. Again, we just wanted to create space for folks to react, respond specifically in regards to the recommendations.
And the report is in the agenda, so it's a lengthy, really well thought out report and recommendation to the board. So if you haven't had a chance to read it, it is in the agenda and really worthy of your time.
Yeah, I think the most important part was the recommendations for the staffing after the approval, but it was a long day. I think robust is a good word. Not my word.
I can't always use your words, Cheryl.
But yeah, I do think that we should share the positions that they came up with because I think that's important. They will have a effect on us because where we fit in there is probably going to be really important. But Jeff has something to say before me.
Thank you, Cheryl. Just as I'm looking at these docs, and I know there's a lot in here, I'm kind of, my attention's drawn to the complaint process. And right as Cheryl, you were raising before, the issue of having the ability to bring complaints regarding misconduct involving law enforcement to a place other than law enforcement. And maybe if there's more to be said about what's intended for the complaint process. I know where we are in time, but just how that might relate to the concerns we have of the ability to do that specifically related to persons that are in custody, conditions with the sheriff. This is meant to be overlapping with that or a separate process. This is, I think, on pages 79 of the packet. I'm just kind of putting that out there in general. I don't know if anyone who's been part of the process would wish to speak to that, but it jumped out of my attention based on what we had talked about before.
So what's being shared now is the staffing sort of diagram of the office. And it looks like they've broken this down over the course of 3 years. The office would be led by 2 co-directors, one with an internal focus and one that is sort of more externally facing with the community focus. And I believe there is, sorry, my Zoom stuff is in the way of other controls here. Let me just back it up just a little bit. And I believe, oh, actually, no, sorry, let me zoom in. So the color, the legend down here shares where by each year, where that specific staffing element, if you will, would be implemented. So year 1 would be the 2 co-directors and your sort of your staple staff members, your reconciliation coordinator.
Patrice?
Yes. Yes.
Just to be clear, this is the recommendation.
Right. No. Yes. The
So
recommendation to implement in year 1.
So we don't, once those 2 directors are hired, I mean, they could decide that there's a different timing for certain things in this. So, I mean, this was the recommendation, right?
Yes. So just to be clear, the way we're discussing this is within the confines of what is recommended, not necessarily what will in fact happen, because more discussion and deliberation would have to take place, right? But as recommended over the course of 3 years is the implementation phases. You have your 2 co-directors, you have a reconciliation coordinator, a budget and policy analyst, a data analyst, EA, and then a language equity coordinator. And then in year 2, you have a communications specialist, a participatory budget coordinator, which I can say, being somewhat familiar with participatory budgeting processes, this is a pretty heavy lift here. So glad to see that there is staffing being made available for that. And then support, which I would have to dig into the report to understand exactly what this piece was, but, oh, I'm sorry, an advisor, community advisory board made of members with lived experiences. And then in year 3, excuse me, there's a resource specialist. So fund development, I thought that was really interesting and great to have. Certainly having someone tasked with grant writing and things of that nature. I'm assuming that's what that's for. And then racial equity fellows, and then champions that are out in the community and across the various regions. So I know we're coming up on time, but again, we just wanted to give space for folks to respond and react, but pretty thorough picture here. Sure.
I'll just say I'm really excited that this is moving forward. I recognize this came from years of work on behalf of the community and was a very comprehensive, lengthy process. So I think it'll be exciting to see it realized as we move forward and get folks into those positions, especially with the sort of mandate of this group. The data analyst, I imagine, is going to be one of our favorite people to have at our meetings. All right, anything else? We are close to time, I think 1 minute over. Any other questions or public comment before we adjourn? Our next meeting, by the way, will be in 2023, February 2nd of 2023.
I just want to uplift the fact that we don't have updated Zoom links for everybody for the next year's schedule. So that's why it's tentative right now, but we will look at the calendar, start scheduling out our quarterly meetings for the next year. And all of the current members and oncoming members will be sure to get you guys those calendar invites. I know that is a great help to you all as well as us, so.
Wonderful. Thanks, Patrice. Anything else, anyone? Going once, going twice.
Go vote.
Go vote. Go vote. I already voted. Good to see you all. Thanks, everybody.
Bye, everyone.